Welcome, everyone. You've joined our monthly free tax section CLE. The topic is income tax treaties for humans, understanding the residents and the tiebreaker rules. We've opened the room and are giving the participants a few minutes to come into the room. We will get started in about another minute. All right, we have a good number of participants. We can get started. You have joined the income tax treaties for humans, understanding the residents and tiebreaker rules. This is a presentation which will be led by, given and led by Philip Hodgen of HodgenLaw PC. Phil Hodgen is based in Pasadena, California. He focuses exclusively on international tax law. His clients are high net worth, multinational families, their investments, their operating business. He started his practice in the 1990s. And early in his career, Phil had a job that involved actually preparing income tax returns, which he believes affected the legal advice that he provides on tax returns, made him a far better tax lawyer. Many of us can agree with that. He says he's now been banned from touching tax return prep software by his team. Phil, it sounds like there's a story there. He is the past chair of the International Tax Committee of the State Bar of California's tax section. Phil, we are happy to have you today. I am going to go ahead and share the code for today's CLE. It is 8456 for the Florida Bar. My name is Jennifer Migliori. I'm the Assistant Director of the Education Committee of the Tax Section of the Florida Bar. If you have a great idea for a tax section CLE topic, please reach out to me at jmigliori@dwaynemorris.com. Whitney, if you have a moment, if you can just drop my email in there. Not sure if you have, but please do at your convenience. I want to take this time to provide some updates on the tax section of the Florida Bar. As a reminder, the tax section's monthly free CLEs are available on YouTube. So you can actually go to the YouTube link and go back and look at some of our recent programs. That's a great resource. And the link is usually sent with our periodic email to Florida Bar tax section members. And then our next free tax section CLE will be held on June 26th. It's about 2 weeks away now. Yep. About 2 weeks away, on the topic of recent Mexican elections, a new landscape for the wealth industry. And this is going to be taught by a Mexican tax lawyer, Mauricio Cano de Valle. So it should be a very, very interesting one. There's a lot coming out of Mexico, so we feel that this is a timely one. The next tax section CLE after that will be held on July 24th, if you want to mark your calendars. Past Chair Michael Lampert will join us for Circular 230 and Ethics in Tax Practice presentation. So we're looking forward to that one. And then as a reminder, on July 4th through July 6th, please join the tax section for the annual organizational meeting. It's a long-standing tax section tradition held at the Omni Amelia Island Resort. Registration is open for that through the tax section. And then, of course, the organizational meeting wouldn't be complete without our traditional Ullman Year in Review CLE. Programming Chair J.J. Well is recruiting speakers to present 20 to 30-minute segments on a variety of tax law issues. The program will take place from 1 to 5 p.m. on Friday, July 5th. So new tax lawyers, this is a great opportunity for you to be able to test the water, see if you want to get involved with the tax section. So definitely reach out to us on that. Questions. If you have questions throughout the presentation, please go ahead and add those to the chat box. If Phil is able to get to them during the presentation, he'll do that. Otherwise, we will allot some time at the end of the presentation to cover your questions. So we will see those toward the end of the presentation, and they will be addressed. I will now pass it off to our speaker today, Phil. Phil, we're excited to have you presenting today.
Thanks, Jennifer, and thanks, Whitney.
Thank you.
I'm really happy that I'm here. I went to the Miami International Tax Conference for the first time ever this year, and we'll go back again. And so I'm glad to be on this. So the backstory for why I'm banned from software is we were doing a VDP, and a client called me over the weekend and said, oh, here's this trivial change. And of course, I changed the first year in the 6 years of tax returns we were cleaning up, and my little alteration was a shit show, and it just cascaded through. So they came and erased the software from my computer on Monday. So there we go. I am not competent to touch software necessarily. This is a presentation about using treaties to toggle resident versus non-resident status for a U.S. tax return for someone. And I'm going to start basic and stay basic, but I will talk about how I use this in practice. We do a lot of expatriation projects. And so for people like you who are handling people who are coming inbound immigrants, you will be looking at treaties as a choice for that first year, maybe to toggle residents versus non-residents. You know, someone comes late in the year and you don't want to be filing the part year tax return for August through, December or something like that. Anyway, so there's where we are. It's going to be basic. So for those of you who are very experienced, my apologies in advance. So, as said, how are you going to use a tax treaty for converting an individual from resident alien status, and I'm using that word in quotes because I mean the definition in section 7701, to non-resident alien status, and again, as defined by section 7701. And I'm going to mostly refer, when I refer in here, to the model income tax treaty, because that's the direction that our poobahs in Washington, D.C. want to drive the bus. And so you look at a lot of existing and especially older tax returns, they're not going to be as anal retentive as the model income tax treaty is. I have learned through sad experience. I used to be one of these people saying, oh, there's some confusion and some uncertainty here. If only the government writes some regulations. I've now decided this is actually the dumb thing. Every time the government writes regulations or promulgates rules, things get worse, never better. So, just my bias there, but you can see where the government is going with the income tax treaty. Particularly, you'll see, I think, references to expatriation that in the newer treaties that don't exist in the older treaties. So let's start first and just say, what are treaties? And the bottom line is that treaties are a parallel set of federal law on par, theoretically, with the Internal Revenue Code. So here's a snippet from an opinion from the 1880s, because why not, which lays it down. And basically what happens is, how the United States Code comes into being, and Title 26, Congress plays footsie with the president, and eventually a bill is signed, and hey presto, we have a new tax law. Treaties are slightly different in that we have our serious people in dark suits go confer with the serious people in dark suits from another country, and they negotiate a bilateral treaty between themselves. And when they're all done with that, they bring it back to the Senate, and the Senate, looks at it and goes through its process and blesses it and ratifies the treaty. And when that's done, we have this treaty becomes federal law just as much as the United States Code is. Now, the problem is, what do you do when treaties are inconsistent? And so the first answer is you try and avoid inconsistency. Like I suspect that your clients are like mine. They do not want to be the crash test dummy in tax court cases testing what does this mean, children. So we try to you arrange the facts in advance, because that's what you can do if you're planning, so that you avoid any inconsistency. But if you do have an inconsistency, what do you do? Well, the first and most important thing is Congress can override a treaty by a later statute. And so the most recent experience that I've had with that is Section 7874. And this is the rule that said, New York Stock Exchange companies were reincorporating in Bermuda or stuff like that, and they'd suddenly become foreign corporations. And instead of being taxed on their worldwide income, they're only taxed on their US source income, yet they would leave their headquarters in Manhattan. Well, Congress didn't like that, so 7874 came into being. And 7874 says explicitly, we don't care about treaties. This overrides treaties completely. You can't use treaties if you're in this bucket. So these things happen, and you're going to have to look at, if you are looking at variation on how is somebody taxed, or what's the tax rate, and what is taxable and what's not taxable, you'll need to look at specific code sections to see if something's like that. But the general rule is that courts try and harmonize the seeming inconsistency. A lot of times that happens. I'm not going to talk about that, because for the most part, in my experience, I've never had a problem with, are you a resident or are you not a resident? I mean, ultimately, it comes down to a factual question, but usually the facts are clear enough so that you don't have a problem. And as you can see later on, there's a series of if-then statements, and the bottom one is, oh, where's your passport? And a resident alien, by definition, doesn't have a US passport, so that's going to toggle to the resident alien's country of residence. So, I mean, citizenship, pardon me. So there we go. Anyway, just know that they are parallel sets of federal law. They sometimes agree with each other, sometimes don't. And you may have a problem, but probably not in this question of residency. Now, the treaty is not the only way to toggle someone from resident status to non-resident status for income tax purposes. So there are these three tools that you can play with. And the first one is the closer connection test. And this is an override for the substantial presence test. So a green card holder cannot use this. It's Form 8840. And you say, hey, look, IRS, I really live, quotes, in the generic sort of common sense in this other country and not in the United States. So therefore, I get to be a non-resident alien. And what this does is, if you succeed at this, it simply makes the substantial presence test not apply. And when can you use this? Well, you have to be in the current year where you're trying to decide whether you're a resident or not. You have to be in the US under 183 days. So in other words, it's that weighted average 3-year test for the substantial presence test that has toggled you into resident alien status, not necessarily the year in the current year. And so that's the first thing. And then second thing is you fill in, all the essay answers on 8840. And in my experience, I've never had these things bounced. So it works really well. Now, the advantage of this is, you see on the far right, what kind of column, what kind of tax return do you have to file? And so if you use the closer connection test, The person is not a resident alien because they have a green card, because they don't, and they wouldn't. They're only a resident alien because they are, they toggled the substantial presence test, and therefore the closer connection test takes the substantial presence test away, and they're just a plain vanilla non-resident alien. And so U.S. source income gets reported, but otherwise nothing else. 1040 NR is simple. The exempt individual, we've all seen this. So the most frequent one tends to be students. So if you're here and you enter the United States as a student, and you got the F1 and you do all that, but diplomats as well, a few other categories. Medical. Medical is, my experience, not as wide open as you would hope it would be. I will tell you a story about someone who is now dead and a long time, but he was here in the United States for a lung transplant. And so he went through the surgery and he was here for a long time afterwards because he had to be close to the hospital for the checkup and all of that stuff, and everything was fine eventually. But he toggled the substantial presence test, and he had a lot going on in his home country, and we really didn't feel like filing 1040s with 5471s and all that BS. And if you look technically at the exemption for people who are here for medical reasons, he was staying in a condo near the hospital because he wanted to be there because he had to be there frequently, but he certainly wasn't there under doctor's orders. So he complied by lying. So let's just put it that way, and never filed a resident tax return. But if you do it correctly, you're going to file a 1040 NR. And again, these days that you're in the United States don't count towards the substantial presence test, and therefore you never toggle the substantial presence test. You never become a resident alien, and therefore you just file a plain vanilla 1040 NR. And the third way, which we're going to talk about today, is treaty. And someone who is a substantial presence test resident alien or a green card holder can use this method. So someone who is a substantial presence test resident alien, this is going to be someone who's in the United States more than 183 days, and therefore they can't use the closer connection test. Green card holder just is a resident alien because they hold the magic visa. Now, here's the difference for the tax return that this person prepares. The tax return, the person has resident alien status, and the effect of the treaty claim, I want to be a non-resident alien, is that you compute your tax liability as a non-resident alien, yay. But you're a resident alien, and therefore, for all of the fund compliance purposes, you are going to have to comply with all the hoo-ha that the government likes to see from resident aliens, 5471s, and all that fun stuff. And there are variations, and some forms will have specific rules for if you make a treaty claim and you establish yourself as a non-resident by virtue of a treaty, you don't have to file the form. Some say, no, you got to file a form anyway, and some are vacant and vague, and you don't know. And so I'm not going to give you any specific guidelines because I can't pull them out of my head and in the spur of the moment, but I'm going to tell you that in general, the treaty benefits of claiming non-resident status are going to be your U.S. tax liability because your all of the foreign source income that this person earns is out of bounds for taxes. But the compliance burdens are going to be heavy, and so you're going to have a grumpy client saying, why am I preparing all of this stuff when it makes absolutely no difference to my tax return? And you go, yeah, well, government. So these are the three ways. And I'm going to talk about, now we're going to use the treaty, but just bear in mind that they're going to be, there may be a very expensive tax return that does absolutely nothing. I mean, imagine a 5471 with all the fun in it. Does it pass any subpart F income through to the 1040 NR? No, it does not. Yay. So let's now go. One final thing. can you use a treaty for a US citizen? The answer is no, because if you look at the Internal Revenue Code and the tax system of the United States, it will tax someone who is either a citizen or a resident of the United States. And so the only thing that a treaty does, it enables you to toggle residence on and off. It does not enable you to toggle citizenship on and off. The only way that you're going to toggle citizenship on and off, well, it's a one-way switch, isn't it, is by renouncing US citizenship. So expatriation, and the government has a code section for that, section 877 cap A. So in general, well, not in general, absolutely true, US citizens will not be playing this game. You're only doing this for people who do not have the magic passport, and for reasons of visa status or for reasons of too many days in the USA, have found themselves to be in the status of resident alien. There's this thing called in addition, and just a sort of side detour here, this thing called a saving clause. Every treaty that I've ever seen has it. More recent treaties tend to have this as one of the paragraphs in Article 1, but the older treaties might have it anywhere, like in the back of the bus, Article 23 or something like that. It will never use this word saving in it. So if you want to find the saving clause, the easiest way is to get the technical explanation for the treaty. So a treaty is this is the formal agreement, and then the government will write a technical explanation. This is what all the articles mean, so it'll be 50, 60 pages long. So find that, get the PDF, open it up, do Control F, and type in saving, and it'll take you to say this is where the saving clause is. And the saving clause basically says, we, the United States, reserve the right to tax our citizens and residents as if this treaty never existed. And so this is because we have this worldwide taxation thing, so that's why the saving clause exists. So even if the code says something different, the saving clause always reserves the right of the Internal Revenue Code to apply the normal income tax to a citizen. Therefore, either because you look at the way the Internal Revenue Code is written or because of the treaty with the saving clause, citizens are always subject to worldwide income taxation in the United States, no matter where they live. And the point of this slide, which I've already talked through it, is, saving clause. I went through the years of calling it the savings clause. Well, no, it's not the saving clause. That's the anal retentive way of looking at it. But reserved would be a better way to describe it, in my opinion. But, I'm not the king. Because the government of the United States reserves the right to tax its citizens or residents in a certain way, notwithstanding the treaty. So here's an example of the saving clause. This is the model treaty. And this is the pattern all the way through. And I give this to you just because it will become important when you're looking at resident, non-resident, not only for toggling the resident status, but also once you've decided which way you go, then you have all of the other clauses. Well, how are dividends taxed? How are pensions taxed? Blah, blah, blah. And the saving clause will say, well, even if this person is a resident, this is out of bound, except, and there are always exceptions. And you look in the saving clause and you'll find the exceptions. So here we have except to the extent provided in paragraph 5 of this article, so here are the words. So you look in Article 5, in paragraph 5 of this article, and you'll see here are all the things that a US citizen and a US resident can use in the treaty, even notwithstanding the saving clause. The other important thing to look at, and this is directly applicable to what I'm talking about right now, is, the saving clause says the United States can tax its citizens and residents as if the treaty doesn't exist. But resident is defined as within the treaty. So the treaty's definition of resident not the Internal Revenue Code's definition of resident. So what you're going to see as we go along is, let's say you have someone who has a green card and they're living full-time in another country. So because of their presence in the other country, they're a resident for income tax purposes there. And because they have the magic green card, they're a US resident here. We'll go at Article 4, which is where the tiebreaker rules are, and we go through that and we successfully prove that this person should be treated as a resident of the place they're living, not as a resident of the United States because they have the green card. What that does is this person is no longer a resident for the treaty purposes, and as far as the treaty is concerned, they're just a garden variety non-resident alien in the United States. And so this means that all of the reduced withholding rates, the reduced tax rates, the who gets to tax the pension and all that kind of stuff will apply as if this person is just a regular alien and the green card didn't exist. And by contrast, I'm giving you just the USA-Italy saving clause from 1999, roughly the same, but over time, the way that the government likes to write the treaties varies. So, and you can see they're calling out, resident is defined as a method as defined in the treaty. So, again, my words got ahead of my slides. So here's the slide that just says, if you successfully use these the treaty tiebreaker rules that we're going to talk about in a sec, you're going to be able to use whatever kind of tax reduction opportunities are open in this particular treaty. So, I talked about the exceptions in the tiebreaker. So here's the one from Italy. So you can see, say, okay, you're a US citizen, okay? So you're not allowed to use the treaty at all, except for these things. And so you look and you say, well, what if I had a US citizen living in Italy? Can I override the saving clause, which bans me from using the treaty, and actually use the treaty? And the answer is, if you look at little a, and it says, well, if you're a US citizen living in Italy, paragraphs 5 and 6 of Article 18 for pensions will apply to you, so go check it out. So just because the saving clause exists doesn't mean you're doomed, and you may be able to do something and get some sort of tax benefit from the treaty, even if the saving clause applies to you. All right. So let's start into the nuts and bolts of the tiebreaker rules. First things first, when do you know that you're allowed to do this at all? And the answer is only a dual resident taxpayer can use the treaty tiebreaker rules. And side detour, there's a lot, well, tax law is just full of it, isn't it? But there's a lot of very similar naming conventions and very similar phrases in the code. So if you look in the Internal Revenue Code and the regs, it'll talk about a dual resident taxpayer. People talk about a treaty tiebreaker non-resident. If you're doing a tax return for someone who became a resident, the year of inbound or the year of outbound, you'll be doing a dual status tax return. My only comment here is be very slow and be very careful with the words that you use defining it, so that it's easy to move fast and hand wave and you know what you mean inside, but your naming conventions will help you get down the road and not accidentally make a mistake. So, but specifically dual resident taxpayer is what we're looking for. And just stepping way, way, way back, the first things first is treaties will always say you can only use this treaty if you are a resident of one or both countries. So if you have a French citizen who is living in Hong Kong and has some US source income, can that person use the treaty? The answer is if the French government looks at this citizen as a non-resident for income tax purposes of France, the answer is no. And so this is really a resident to resident. So this is the first hurdle. They're resident of one of the countries. And then if you look and you say, what does resident mean? You remember, just a little bit back when I was talking about the saving clause, I was precise about saying a resident as far as the treaty is concerned. Well, the reason it gets kind of weird and confusing is because the first line of the treaty says resident for treaty purposes means whatever resident means under your local law. So, if you have someone who is a resident of the United States and a resident of Italy, you have to check and see, well, why is this person treated as a resident? And so typically countries are going to have the count the days rules, so whatever their version of the count the day rules is, but you're going to have to look at the rules of that contracting state. So you need to find that. So wherever they are, you need to find out what that is. And you can see here that, so we've talked about, in general, treaties only apply if you're a resident of one. Well, for the tiebreaker rules, you must be a resident of both countries. So this is the little preamble to in the model treaty, Article 4, paragraph 3, which lists all the tiebreaker things, and we'll see these in a minute. It says, if you are a resident of both contracting states, meaning USA and Italy or USA and Mexico or whatever the two countries are, then your status is determined, and then there's a whole series of if-then statements. If you have a permanent home, blah, 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 blah. We'll see these. So here is the clause that says you have to be a resident of both places. And here are the wrinkles that I've seen. So we go back to the definition of resident in Article 4.1 of the model treaty, but this is an example of more recent iterations in the treaties where the government is starting to add these kind of clauses in. There are countries that have, for instance, laws that say, come in, live here, pay us a flat tax of X, whatever X is every year, and you're fine. That covers you. So Switzerland is a common one. Italy is a common one. I mean, more and more interesting because Italy's trying to push this. UK has, or soon will be had, sort of a weird thing where you could be a non-domiciled person. You have to look very carefully, and I'm not going to give you any specific guidance because I don't know anything off the top of my head, but anytime that you have, for instance, a green card holder living in Switzerland or Italy under one of these things, they call them forfait, forfeit under French, or a fixed fee basis, you have to look carefully to say, does the treaty actually make you a resident, at least as far as the, this tiebreaker rule is concerned. So in a very hand-wavy sense, because I don't know it entirely, the Italian system is you go and you live in Italy, you're taxed like a normal resident on your Italian source income, but for your foreign source income for 10 years, you just pay a flat tax and you're done. So the question is, would this work in the USA versus Italy situation where you had a green card holder that went and lived in Italy? The answer is, when I face things like this, I'm facing them in the context of an expatriation, and we make damn sure that they're not US residents as a matter of Internal Revenue Code. So this is an example of, I'd rather not get into discussions and making angels dance on the head of a pin with the IRS. I want to make it clear. So the other thing that you have to watch out for is, for am I a resident, is when was your residency starting date? So if someone moves to the Netherlands or wherever in March, did you become a resident taxpayer of the Netherlands as of January 1? Or March when you set foot there and you went to the local municipality and you registered yourself. Similarly, when did you become a non-resident of that country? I mean, I had a conversation with someone from New Zealand and he said, oh, if I want to stop being a resident, it's easy. I go down to the tax office, tell them they register me as a non-resident in the system, I'm out. So the point here is that you need to be careful and you need to find a tax professional in the other country. So, and that counterpart is going to tell you when was the residency start date and when was the residency end date. Because people will come into my office, and I expect they'll come into your office and say, oh, I'm going to move to fill in the blank country and I want to be a treaty non-resident for the whole calendar year in the United States. And the answer is probably can't do that. It's going to be a part year thing, and which is going to be a mess. And again, let's try and plan around the part year thing so we can have a clean line as of December 31st. And, you know, I'm sure your clients don't express it this way, but they come into my office and we sit and we chat and they say some Baroque variation of, well, can I lie and get away with it? And the answer is, you can try. I don't want to play that game for you, but just be aware that the government in extremes can and will go ping their counterparts in the other country. And here's an example, a little excerpt from green card holder went to Germany, claimed he was a German resident, and the IRS checked with their German counterparts and said, well, actually, you know, and the taxpayer had a hard time. So this, you know, life's too short, right? Just do it right. You can plan ahead. In my expatriation practice, we'll have 5 or 6 going on these at any given time. I tell the clients your primary purpose in this exercise is to exit the US cleanly. Bang. And so, you know, leave a little bit of money, tax money on the table if you must, but exit cleanly. And so that means drawing bright lines and not playing silly games like this guy did. So, you know, slide with some, you know, US residency start and termination dates. You know about this stuff. And anyway, there's the site to the regs and you can read it up to get the details. Where do I use these and in the context of a treaty? Well, the first year of US residency, a lot of times people will get their green card mid-year, but they haven't cleaned up their business affairs in the other country before getting the green card. So they have a start date of June, but they've still got a mess in the other country. And the mess I'm defining no great shakes. It's like, well, you have a bunch of PFICs in your investment account. Get the hell rid of those. And too late, they're already US residents. Well, if you can successfully make a treaty assertion that this person was a resident of the country they came from and not a resident of the United States by using the tiebreaker provisions, then yay, you know, they come in June, they get the green card in June, August and September, they are liquidating assets still as non-resident aliens, and they don't have the PFIC problem and, you know, all of that. So that's the context that I will look at a treaty claim in the year of entry to clean up messes, compliance messes, CFCs, PFICs, trusts, the like, just to make the tax burden lower, because, you know, accumulation distributions and all that fun stuff from trusts, PFIC problems you're familiar with, you know, stuff like that. Now, having figured out that you are a dual resident taxpayer, you are a resident under the local laws of the other country and the United States, and please, for, you know, to make the CPA who's preparing this tax return happy, make it a full year. Let's talk about how to apply the tiebreaker rules. So again, first you're going to confirm first a resident of one of the countries, yay. Second, a resident of both of the countries, yay. And then third, you're going to apply these tiebreaker rules, and they are, you don't get to choose which country you want to be a resident of, which would be cool, but that gives too much power to the taxpayer. Instead, the tiebreaker rule is going to tell you if these factors exist in your life, then you are a resident of this country or that country. And by implication, if you are a resident in one place, you are not a resident in the other. And so there's a series of things, we're going to go through them. And then the final one at the bottom is, well, if you can't figure it out and it's still unknown, you go ping the IRS and your local tax authorities and let them fight it out, right? No, lol, no. If you want to put your destiny in the loving hands of two tax authorities who will take 2 years to figure it out, go for you. I would not do that. So let's talk about how we'll go through. Here's the tiebreaker rule in the treaty. And I'm going to show you Mexico next. It's the same, very, very similar. I mean, a few odds and ends differences. So you see A, it has actually two things in there. The OCD part of me really resents this. A should be permanent home. Yes, no. If no, center of vital interests, like that. But, again, I'm not the king. So you look for someone and say, where do you have a permanent home? One or both places. And if your practice is like mine, they got homes in the United States and they got homes in their home country. And then if you've got both or neither, right, then you're going to say, okay, where's your center of vital interests? And that's a defined term, and you can see what, we'll talk about this in a second. If it's hard to figure out where your center of vital interest is, and you can't get a definitive answer, you say, where's your habitual abode? And we'll talk about what that means. And then if you say, well, it doesn't have a home, it has a home in both countries or neither. Center of vital interest is sort of balanced 50-50 between the two countries. Habitual abode spends the same amount of time roughly in both countries. So it's up in the air. You look at the passport and you say, you're a resident of the contracting state where you're a national. So you look at your passport. So this means British-US citizen treaty. If you're trying to invoke this and the person is a resident of Dubai, you can't use that. And then finally, we go down to the mutual agreement. Here's the one from Mexico, very, very similar. I mean, the wording is slightly different. So over time, from between 1994 and 2016, the IRS sort of tweaked it, got the copy editor out and fixed it up a bit, but the same thing. Permanent home, center of vital interests, habitual abode, national mutual agreement. Boom, 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 boom. And so here is my little quickie sort of summary, breaking it out from diplomat speak in the treaty to if-then statements for those of us who love if-then statements. So the first one is permanent home available in only one country. That's your place. Permanent home in both, hard to tell. Okay, and permanent home, you own it or you set it aside, or you could have a long-term lease will work as well. Permanent home is available in both countries or neither, right? Where's your center of vital interests? And if you can pinpoint that, then that's your place. So to give you an example, long ago, he now has a green card, but for a long time, I had a Mexican client who would come back and forth between Mexico and the United States and frequently spend a bit too much time here. But owns a big manufacturing plant in Mexico and has homes there and family, blah blah blah, but has a very nice house in LA. Well, center of vital interest was Mexico, so we would use that successfully. Third one is habitual abode, and so you're looking at that, and yeah, you'll see in a few slides the difference between center of vital interest and habitual abode is kind of nebulous. And you'll see, in fact, in a court opinion that I have some slides for in the next two slides, you see that I think the judge got them mixed up. But then you go down to nationality and the two countries figured out. So let's talk about this. So Aroeste, this is a very interesting case. Decided in the Southern District of Federal Courts in California, so San Diego. The lawyer who handled this for the Mexican client is Patrick Martin. He's at chamberlainlaw.com. I've known him for many years. He's, was/is in California, was on the executive committee of the state bar tax section with him. Good guy. My opinion is if you have a treaty beef like this, go talk to Patrick first. Anyway, so we had an opinion where Aroeste, he and his wife, he had a green card. His wife was a naturalized citizen. They lived in Mexico. I mean, as you'll see, the whole ties are here, and the government came after them for FBARs. And the question is, did he have an FBAR filing requirement or not? She did because she was a citizen. But the beef was, I'm a green card holder. I've been living in Mexico forever. I'm a non-resident alien. Go stuff yourself. Patrick won. Yay. So here is you can see here, this slide and the next, we'll just walk through how the judge reasoned through at the trial court level. This incidentally was appealed it was a motion for summary judgment. The taxpayer basically won. The government appealed. The taxpayer cross-appealed for some minor part, and then they both agreed to dismiss it with prejudice earlier this year. So there's nothing at the appeals level, but this is good stuff. So Aroeste is a resident of both contracting states, Mexico and the United States. Mexico, because he's there, filing resident tax returns. USA, because he has a green card. Okay. So this slide here talks about permanent home. And there's not a lot of authority out there in the world for what does permanent home mean. So the judge in this case cites to the model treaty, which of the OECD, not even the US one, and it says, where there's a dwelling place available at all times continuously. So, and you'll see that Aroeste had his house in Mexico, he had a vacation property in Mexico, and he had a condo in Miami. So this was enough to have a permanent home available for him in the United States and in Mexico. Then, so here you are. So he had a Florida condo. He had somebody handling the Florida condo and forwarding the mail to him and all of that stuff. But the fact that it was available to him was enough to be a permanent home in both countries. Next, we say, okay, he had a permanent home. And remember, we're still at that A, the first one. Where do you have your permanent home? Well, both. And it says, if you have it in both, now where's your center of vital interest? And here you have the slice out of the opinion. And I gave you the full thing, downloaded it from Pacer. So you have it as one of the handouts. And go to Pacer if you want to pull up the points of authority, a memo of P&As by the government and by Patrick, and very instructive, useful stuff for you. So anyway, we're talking about center of vital interests. And, you have a question of depth of connection to a place and just quantity, right? So quantity would be how many days a year do you spend there? Depth of a place would be, where do you go to church? Where's your dog? If you're in Florida for 2 weeks, but the dog's back home and your pets are still in Mexico, kind of indicates, so that's a qualitative thing. And, you see here, in the text starting at line 22 and a half, they lived in Mexico, member of social groups, blah, 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 blah. They're talking more about qualitative things there. And then you see at line 27 and a half, and line 1 of the following pages, I had to sort of bolt it together. The judge says, well, he spent 75% of his time in Mexico. And if you look through, the discussion of what does habitual abode mean, it's more the quantitative thing. So here I am at the slide talking about what I'm talking about right now. So think about the center of vital interest as a qualitative thing and habitual abode as where do you spend more time. So back to my client who was in and out of the USA for a long time, but he had the big business connections and family, his parents, and then parents eventually died, but he had friends and school connections and, like a normal life. A couple of homes in Mexico and whatnot. But his center of vital interest was, I got this big company that's generating a lot of income for me. This is my life. I'm a director, blah, blah, blah. So the fact that I happened to spend 200 days last year in Los Angeles doesn't swing the needle one direction or the other. So that's the kind of way you think about it. And you can see now that where you can get into discussions in air quotes with the government about what does this all mean. I need to zoom fast so we can leave some time for questions. What's the required paperwork? Required paperwork is Form 8833. So Section 6114 logically says, if you're going to use the treaty to alter your tax liability, you should tell us about it and tell us on Form 8833, which is the treaty form that you bolt onto your tax return. And specifically, there's some things that you don't have to report, you just do. But residency toggling is one that you specifically must. And you can see here, I've given you the citation to the regs under Section 6114. And because what would the Internal Revenue Code be without redundancy? The same thing is talked about in the 7701B regulations. So they say the same thing, but there you are. And the 7701B-7 regulations say if you do this according to what we tell you here at 7701-B-7, that also quenches our thirst for what you must do under Section 6114 of the Internal Revenue Code. So it all works, but I'm not bitter about the redundancy, not at all. And I don't judge the people who wrote those. So Form 8833, how I would do this. So you fill in your name and all that fun stuff, yay. You have to figure out what is the requirement. Why are you following? So these are why are you filing? And these are the checklists. 6114 requires you to report treaty differences. I'm toggling from resident to non-resident, and the regulation I gave you on the previous slide. Similarly, 7701B-7 regulations require this to be reported. So you check that box too. And, this third box, check the box if the taxpayer is a US citizen or resident or is incorporated in the United States. This is one of the, and you read after I toggle this thing and file it, I'm not a resident, am I? So am I a resident at this moment? So I just check it. It's one of these ambiguous things in tax compliance that bedevils us sometimes. And it's not a big deal, but it's irritating. And then you tell the government, what am I doing and why am I entitled to it and where am I claiming? And so you can see, that you list the article. So here I'm saying, well, because of the habitual abode, 403B, this specific one that I'm claiming, this is the one that I'm going to claim toggles me from resident to non-resident status. What does it do? It overrides 7701B1 cap A, which is the definition of resident alien. I don't get down to the nitty-gritty details of am I a resident alien because of green card or substantial presence test or, God forbid, election? Though I can't imagine someone making a first-year election to be a resident alien and then simultaneously for that same year making the treaty claim. It could happen, but I can't imagine what it is. And then, you know, line 5 again, am I specifically required under 6114 to report this one? Yes. And 8, the subsection is the one that requires me to report this. And then line 6 is just a little essay thing. So you write enough essay, you don't have to get verbose, and don't. Legs should be long enough to reach the ground. Give the government just enough so they understand what's going on and be done with it. Procedural details. This is where we come into the important stuff. Can you make the treaty claim on a late filed tax return? Yes, you can. And in fact, Arowesti did this, right? He went back and filed a bunch of 1040 NRs, and he did it that way. How late can you be? I don't have an answer, but I think the statute of limitations, as long as it's open, you can do this. Does your treaty claim fail if you don't file 8833? No. The Arowesti case explains why the worst that can happen to you is you attract a $1,000 penalty. So it does not deny you the treaty benefits. Collateral damage to watch out for. Here we come into the practical stuff. Impact on FBAR filing status. Remember that the FBAR filing status is tied to your residency as defined under Title 26. So watch out when you're doing this that you synchronize what you're filing for FBARs with what you're doing on the treaty claim. Expatriation. If you make the treaty claim and you've had a green card for too long, long-term resident, then this is a termination of your lawful permanent resident status. This is the 7701B6 language, and that's an expatriation event, and that may be bad. But what we do is if we have a green card holder who's living abroad for a long time, we will backfill with a bunch of treaty claims for non-resident status, and that stops the clock ticking towards being a long-term resident. So I commend this to you for expatriation for green card holders living abroad who didn't file tax returns, which is far too common. Conclusion, here you go. Treaties are parallel yet equal. You can choose one or the other, and it's really useful, but it comes with a high tax compliance cost, which is the tax return is going to be weirder, and off you go. Here is just a link to the IRS websites for where you can grab the stuff. And here I am, and I see Jen. So are there questions that I should answer?
There are a few questions that came through, Phil, although I thought the presentation was very, very detailed. But I guess there are, it raised some questions. So I guess we did not lose our audience, which is a good thing.
Yeah.
The first one was about 30 minutes ago. Where's the savings clause in the US-Canada Convention?
Don't know off the top of my head, and it gets messy, especially with places like Canada, where you have a treaty and then they amend it and they update it and they amend it and they update it, but they don't consolidate everything into a new, complete, restated one. And so the only way that I find stuff like this, so this is what I do, is I will download all of those things. I'll get the technical explanation, and then I'll do that Control F search for the word saving, because they will use the word saving in the technical explanation. And then they'll say, well, as it says in the saving clause article, blah, 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 that's where it is. So that's what I do.
So the next question comes in from Abram Smith. Are you able to pull that up, or would you like me to read it?
Please read it. Yeah.
Yes. Okay. Abram says, this question came to me yesterday from a Chile attorney with respect to US-Chile treaty. They have clients who are under the impression that Form 6166, now 6166 is a certification of US tax residency, that the Form 6166 is required to obtain treaty benefits. I understand that some treaty partners require the IRS to certify a person claiming the treaty benefits is a resident of the United States. What is your experience with treaty partners requiring Form 6166 is the first question. How long is it taking the IRS to currently issue Form 6166?
Okay, so the one that we have, which is it's a Swiss family, and some of the members of the family live here, but they have a lot of investments in Switzerland. My experience with the 6166 is it's driven by the custodian of whatever assets there are, because the custodian, if they don't withhold properly, is going to be on the hook. And other countries are just like here. And so it's a custodian getting cold feet and saying, I don't want to give you reduced withholding on dividends unless you prove that you're entitled to it. And they ask for the 6166. So we go through this. I can't tell you off the top of my head, but it seems like there is a lag of many months. Every year we go through this with this family to get the 6166 back from the government. So the answer is, I don't know, but longer than you'd like. The second thing is, do you need the 6166 to claim treaty benefits? Answer is no. If you go look at 6114 and the regulations there, what's happening is simply by preparing your tax return consistently with the rules that are in the treaty, you are taking a reporting position that the treaty applies to you, and the treaty rules are what govern your tax results are. So that controls what the IRS can do to you. Now, what happens in the other country, in Chile in this case, I can't tell you, but at least in terms of the IRS, if you filed a tax return saying, I'm a non-resident, and you didn't bolt on that magic form 8833, but you computed your tax liability as if you're a non-resident filing the 1040-NR, you win. I mean, the worst they can do is tag you $1,000 penalty.
So we have a few more questions, but I just wanted to give the CLE code one more time in case some participants have to leave, and then we can stick around for another few moments to address some of these questions. The CLE code today is 8456. Again, that is 8456. All right. So Abram had one more question where he says, you mentioned an individual obtaining a green card in June of 1 year and the use of a treaty position for that partial tax year. What about deemed expatriation for a green card holder taking a treaty position?
Yeah. Okay. So if you have a green card holder and this person does, the way that you get rid of a green card as far as USCIS is concerned is you file a form I-407. So let's say you don't do that. Instead, you take a treaty position for that green card holder and file a tax return consistently. That is an expatriation event as defined for our Internal Revenue Code section 877 cap A, G something. And so you're in the weird position that the government has decided that you are a non-resident alien and you have expatriated for income tax purposes, but another arm of the government says, no, you're a lawful permanent resident, you're an immigrant, you can live here forever if you want to. Now, the practicalities are you fly in and they'll pull you aside into one of those little rooms that has no windows and grill you for a while. But in theory, the visa says you can come back to the United States and live. And so it's an interesting thing to do, because what happens is if you file a 2024 tax return for someone who's had a green card for 20 years and they've been living outside the United States for 15 years, and you file 1040-NR, claim the treaty, that means that the whole year of 2024, they're non-resident aliens. They're deemed to have expatriated on December 31st of 2023, which may be good or may be bad. So the story out of this is, yes, it will have an effect on a deemed expatriation. It's an actual expatriation. And it can be extremely useful in terms of timing when you want that expatriation event to occur. And I like to use the treaty claim for non-resident status, because if I do that, it avoids the whole mess of a dual status tax return for that final year. Because the default status for a green card holder is you're a resident for the full year unless you do the right things and you have an earlier expatriation date than December 31st. So I like to use this and as a tool. But the bigger point is, no, be absolutely sure you know what you're doing when you do this election. I had the sad situation where a CPA living in the UK, for God's sake, did his own tax return and did this to himself. So, what can you do? Oopsie, too bad.
So the questions keep coming in. We may have time for one more question, and then I'm going to encourage everyone to maybe reach out to Phil Hodgen directly. Phil, are you open to that?
Yeah, I am. And my email's on the last slide. Just ping me an email.
Okay. So one more then. Can you use a tax treaty if you are a resident of the United States and do not comply to be a resident in another country with a tax treaty to claim equal treatment established by the treaty?
Wait, so you're a resident of the United States and you want to be toggled as resident of one country and not as non-resident of the other. Read that to me again, because I'm going to be sure.
Can you use a tax treaty if you are a resident of the United States, so we have a resident of the US, and do not comply to be a resident in another country, so you're not a resident of another country, you're a resident of the US, with a tax treaty to claim equal treatment established by the treaty?
Yeah. So what this goes to is, first thing, are you even allowed to invoke the treaty at all? So you have to be a resident of at least one of the two countries. Right. And so this example, you are. Next thing is, quite apart from these tiebreaker rules, there's a non-discrimination clause, whatever they call it, and says you're not allowed to treat one of my residents worse than you treat one of your own residents. And what I'd suggest is log into Pacer and go through, I forget which one of the memos of P&As, and whoever asked this, ping me and I download it and I'll give it to you. But Patrick actually talks about this in one of his points and authorities that he filed with the court about, hey, if we do what the government says, it's actually going to be, violating the non-discrimination clause. And so that may give you some guidance on how it works. But in theory, you're exactly right. In practice, will it work? Who knows?
All right. If your question has been unanswered, please do send Phil an email at phil@hodgen.com. Phil, the presentation was phenomenal, very helpful. Thank you very much for your time today, for visiting the Florida Bar tax section. Very much appreciated. Thank you.
My pleasure.
Everybody.
Bye. Bye.